Good evening, everyone, and welcome to the second installment of Operation Safe Space Family Law Seminar. For those of you who joined us on Tuesday, welcome back. And for those of you new to the session, please allow me to introduce myself. My name is Robin Paris, and I am one of the project managers with OSS. And this evening, we also have with us Nathan Gibbons and Dr. Yvonne Weeks, and hopefully joining us shortly will be Marsha Hines. We're excited again to have Mr. Rashad Brathwaite leading us through this session. And again, just a couple of quick housekeeping notes before we get started. This will be, again, an interactive presentation. For those of you who are with us on Tuesday, you'll know that Rashad will call you out if he asks a question and nobody answers. So feel free to participate. And then we will also have a question and answer session at the end of the module. And other than those times, we ask that you just be mindful that your mic is on mute. This presentation is being recorded, and our hope is to be able to share this with you following the sessions. So just be mindful of that as well. And also, if you haven't done so already, please feel free to check us out on social media at oss.246, whether it be Facebook or Instagram, to learn more about the initiative. So without further ado, I will hand it over to Rashad so that we can get started.
Good afternoon, everyone. Are you able to see my screen?
Yes, we are.
Okay, good. It's a little different. The last time I hadn't used the screen view, so it shows me a little less. So, all right. So this means that I'm less likely to be able to engage with the chat, but I'm joined this afternoon by Leah Thompson, and Leah will assist me with making sure that any of the comments that come in the chat, that we're able to respond to those as best as possible. So without any further ado, let's jump into our focus today. And we're going to be today thinking through intimate partner violence and international human rights and domestic human rights. How do we move from our understanding of gender, understanding gender as socially constructed, and therefore the questions of roles and how they're related to power, and how, you know, in our last session, and I hope if you weren't there, that you had a chance to look at the recording. And even if you didn't, that you do have a chance to go back, because what we want to show and what we want you to appreciate out of these sessions is that in engaging with the legal system, the way that gender functions in our society at large is not a separate question. Judges are a part of the society, lawyers are a part of the society, police, etc. And so if there are particular views about women's role or women's place, men's place, a boy's place, girl's place, etc., those manifest themselves in the law. And just as a very quick reference point, I would point you in the direction of the Gender Equality Protocol that was adopted in Trinidad, and there's also one in Belize. And you can see some fantastic research there, looking at the views that judges, for example, hold, and the obligations of judges to be active participants in realizing equality through the judicial process. And we're going to talk a bit about that today. So just then, I know I sort of plunged in, so let me return then to some of the areas that we'll be looking at. So Rashad here, Leah, I'm not sure whether Leah, if you can pop your chat on, your camera on, just so everyone can see you. But Leah and I have been working together on some of these questions for So let me change my share screen. See if we can fix this.
While he does that, I'll just say hi and good afternoon to everyone. Pleasure to be here. Unfortunately, I wasn't able to attend Tuesday's session, but I popped in just at the end, and I think the engagement and conversation was extremely interesting. So looking forward to participating today and continuing the conversation that started on Tuesday.
All right, so tell me, Leah, are you just seeing the presentation now? Or
That's correct, yeah.
Okay, lovely. Right, so you've met Leah, and I want to start then, in light of what we spoke about on Tuesday, what's wrong with stereotypes? What's wrong with a judge acting on a stereotype? Lani had mentioned some stereotypes that judges had mentioned, but aren't stereotypes in some ways born out of experience? Isn't there some granule of truth that we start with stereotypes? And as Robin correctly indicated, I will give you generally a chance to respond voluntarily, and thereafter I will call on someone, usually someone I know, or at least in this case, someone who may share my last name. So we'll start with someone who shares my last name, and that can either be Shane or Chanel on this occasion. What's wrong with the judicial system acting on gender stereotypes, for example?
Well, from my experience, I would say that the problem with that is that facts have to be determined on the particular case. So if you are stereotyping my client before you have even heard the case that I have brought to you, then my client will be at a disadvantage, or the litigant in the matter will be at a disadvantage. So that's why we always say that matters must be dealt with on the particular facts as presented in the particular case, rather than imposing a stereotype on the parties.
So ditto, stereotypes deny the possibility of individual assessment. Part of the reason why we so jealously guard judicial function around sentencing. So where the legislature has determined a sentence, so in the case of the mandatory death penalty, a whole lot of that conversation is that there's a violation of separation of powers, because the judicial function, that individual assessment, is what is so important. Likewise, because stereotypes are then embedded in power relations, they may be true, they may not be true, but what is true is that they deny the individual the possibility of that individual assessment, and hence fairness before the court. So we're talking then about in the legal context, but let's now think about some songs, for example, that reflect gender stereotypes. Are there any songs that pop to your mind, in whether from Bajan music, whether you spread your lens a little more regionally, songs that pop out to you that tell you a bit about gender relations, that tell you about, well, this is what a man's supposed to do, this is what a woman's supposed to do, boys, girls, etc. And Yvonne, feel free to jump in here.
And so Rashad, I'm seeing in the chat, we have Nyla Robinson saying brown skin girl, stay home and mind your baby. Not sure, is that the name of the song?
As far as I know, yes. Brown skin girl, stay home and mind your baby.
Right. So we're going to work through a couple of songs, and then we're going to pull this back to Lincoln to some of the broader questions that we want to cover when we talk about international human rights. On screen, you see this lovely, lovely song, melodically sweet. You hear it in effect, and you are in a happy place. And here it is, Machel in Take It Slow. There is a particular line that I want to point to, where he says, gal have a child and she can't boil water, right? And hearing the lyric, it struck me because there were then so many questions attendant to it. Can you think of any songs that encourage or require men to be able to cook? Any song that points to the requirement that men should be able to cook, for example. I'm seeing some more numbers in the chat, Leah. So yeah, feel free to bring those in.
Yes, I'm taking notes. So we have Pakshi Bak Tashima or Tashiman. I don't know if Kimberly wants to share a little bit on what are the gender stereotypes that stand out in that particular song.
Hi, good evening.
Hi.
Pachi Baptishima. I think Naila put the lyric to it. Pachi Baptishima or Pachi Baptishima.
Yeah.
Yeah. Girl can't cook, won't read a book. Pachi Baptishima. So it reinforces that if the girl or the woman, is not able to do certain things, especially just in the kitchen, she needs to be able to.
Right.
You have to send her back home to her mother. To ensure that she could do it to please the husband.
Right. So, and then there's that song that always plays on CBC, one of those songs from Sing Out Barbados, that is just a classic sexual harassment. Somebody help me with the lyrics when she goes to the...
Every time I pass, they
Every time I pass, I'll hear you trouble me.
Ditto, right? So there are all of these songs in popular culture that they either reflect sorts of ascriptions of roles. This is what women are supposed to do, and when women do not do this, this is the sanction. In the case of Every Time She Passed, then there is this very sort of explicit thing that as a child, this was just, it's independence and you're feeling sort of the pride of being Bajan, and this is such a key part of that. But when you listen to it, it's also telling us a story about gender relations in Barbados. Now, the thing then that we want to talk about, even in the sort of noble stereotype, so women are good mothers, for example, there is then as Shane would have mentioned, the absence of individual assessment, but there's also then that women's role is that women are to be reproductive citizens. And so other areas of endeavor, those are not prioritized because then everything is around directing social relations to fulfilling this gender stereotype, even as it is one on its surface. You're a good mother. Nothing harmful there in and of itself, but it is, if we reference sort of Chimamanda, that idea of a single story, the dangers that attend to that. Not sure what happened there. Right. So now we're going to move into typologies of domestic violence, having just refreshed your memories about what we're talking about when we talk about gender and the importance of the question of power. So gender, because we're interested in the political economy, the ways in which power is attached to roles, that who is able to access things and who is not, as embedded in these ideas of what it means to be a man, to be a woman, then we now come back to this conversation about intimate partner violence. And Leah is going to lead us through this, because one of the things that we want to be able to do is to be able to describe to judges and magistrates in very specific terminology what we're learning in research and data, because it then allows us to have a better script for framing the conversation and for how we then might direct a judge or a magistrate to think about an issue, because we move then from talking about a broad description of intimate partner violence that then moves into specific typologies that judges now may want to be able to say, if we're dealing with this type, these are some additional factors I must take into consideration. If we're dealing with this other type, then this requires a particular lens. So Leah?
Thanks, Rashad. And just to add, well, that was an excellent introduction to the different types and how it could be, practically useful for you as practitioners. But also to add, I think it could also help inform what you're asking for in terms of remedies. One thing we notice a lot in Trinidad is that under our domestic violence legislation, there are quite a lot of remedies, including counseling, including different options that may be best suited depending on the type of abuse that's being suffered, that aren't always utilized as much as they should or could be. All right, so we would first discuss intimate terrorism. Intimate terrorism is understood to be a type of domestic violence or type of domestic abuse that is perpetrated overwhelmingly or primarily by men. So in these instances, perpetrators demonstrate a pattern of coercive control, which is functional and instrumental. Coercive control may include the use of physical and non-physical violence. The perpetrator's pattern should be viewed as a course of conduct which aims to exert power and control using threats and intimidation, monitoring and undermining the victim's freedom. If physical violence, sure.
Sorry, just to jump in here, Leah, then you see the connections in some of the ways in which domestic violence is described in our legislative frameworks. And Leah can talk a bit about coercion as then a part of the recent amendments in Trinidad, for example, and how all of this then fits into this concept of intimate terrorism, because it really helps to help us to understand the typologies.
Definitely. So I think, as you pointed out, Rashad, a lot of the language and description here, I think we would see, it would be very familiar and would inform the descriptions and the definitions that we would find in the legislation. In Trinidad, we've recently made some amendments, and Rashad, you could assist me in, I'm not sure exactly which, we had quite a few, exactly what you wanted me to.
The expansion on coercive, on coercion, and we'll come back to that. The expansion on including different forms of coercion.
Gotcha.
Yeah.
Okay. Right. Okay. Let me pull that. I'll pull that back up very shortly.
All right.
Yeah. And even one of the amendments that I think was also interesting in understanding violence to be a pattern of behavior. I think we were also able to distinguish that even where there's one incident of violence, even where it's difficult to, establish that pattern for the purposes of the court of law, there is a bit more leeway there allowed to survivors or victims in terms of proving when violence has occurred or when abuse sufficient to fall under the legislation has occurred.
And this would, for those of you that were here on Tuesday, you would have recalled that one of the participants would have then shared in Barbados, the idea that, for example, where the relationship is broken down, the judicial officer raising questions as to whether a former spouse, now not falling under the classic definition, or at least his interpretation of domestic violence under the legislation, whether former spouses are protected, whereas, as you see in the definition here of intimate terrorism, it's a classic part of the ways in which perpetrators function. And so in understanding intimate terrorism, one of the other things that it also enables us to do when we talked about gender-based violence and why it is a form of gender discrimination is the disproportionate impact and effect. So more often than not, and again, nuance here, we're not saying that men do not experience intimate partner violence, right? What this typology will demonstrate is the ways in which intimate partner violence happens, and why then the specific focus on women is important. But then also, it also then may make sense as to the types of violence that men may experience, for example. And even then, the idea of there is a value equally in us being able to have full understandings of the complexity of individuals, where men and women are capable of being perpetrators, but that conversation cannot happen without context and the reality that 1 in 3 women, for example, in the recent, it's sort of a figure that when I was in, say, secondary school, that was the number that we heard. And then as research has continued to happen over years, we see that that continues to be proven true repeatedly. So now moving on from intimate terrorism, we move on to situational couple violence.
You want me to jump in here?
Yeah.
All right. So situational couple violence is perpetrated in reasonably equal numbers by men and women. However, men usually do more serious damage, and their violence is more likely to introduce fear into a relationship. Violent behavior is expressive and can be frequent and severe. It may be an isolated incident, or there can be a recurring pattern. This type of violence originates from couple conflict. There is no motive for power or control, with links to male entitlement, which I think is an interesting distinction here in the context of the way we describe and understand the other forms of violence.
And important just to conclude this part is that that's not to say that this is harmless, right? There are varying degrees of harm that we see attached to this. So then intimate terrorism, situational couple violence, and then we move on to violent resistance. And I'm sorry that my purple blog is blocking a bit of the text.
I'm sure we could figure it out.
Right.
So basically, violent resistance is overwhelmingly perpetrated by women and is correlated to women resisting their intimate terrorist partners or leaving them. Intimate terrorism progresses over a period of time, and the victim develops and adapts their coping strategies to manage the perpetrator's behavior. When these coping strategies have been exhausted or have failed to protect the victim, violent resistance is used to regain a degree of control and resist an incident of imminent harm. The violence is expressive. And this was the definition, I think, that was most eye-opening for me in terms of in discussions that we've had, or in discussions I've had with others on similar sessions around, what about the men? We have to be cognizant of violence in relationships, not always being perpetrated by men, while also understanding the context of gender-based violence. So I think this was particularly helpful in contextualizing violent reactions or violent resistance that we often find. And then, of course, with that context, we now are able to handle it, I think, in a more appropriate manner.
And so this then ties in very nicely with, say, the discussion that we were having, I think, with Lani around where so the problem of violent resistance is when the judge orders the couple broadly to keep the peace, it doesn't recognize that there is a power relationship and that this was in response to something, right? And so intimate terrorism, situational couple violence, violent resistance, the types of remedies that you may seek to pursue in the context of intimate terrorism, those should look vastly different from situational couple violence, or they could look different. And then in the context of violent resistance, it's important then because what we've seen is the court's willingness in some ways to hold women accountable for responding to domestic violence as a very problematic component, where the idea then is that the system could be failing you and the court may be slow to act, but if you respond in a way to address imminent harm that classically would have fit the frame of self-defense, and we know that there have been developments at common law, etc., around sort of slow burner phenomenon and the ways in which the courts have slowly begun to address that. But that's still one of the areas that legislative reform would be useful in bringing it into the 21st century, for example. But then those typologies, those might be helpful for us in being able to frame a discussion with the court. So what then does this, yes, Leah?
Just also to add, I believe it's the Faculty of Law led by Rosemary Balance, the project that they're doing around the re-examination of women that have been incarcerated in circumstances where they have been defending themselves from domestic violence. So there's some work that's going on in through the Faculty of Law here right now, where there's our attempts to view that specific type of violence through a more nuanced lens, and ask the courts to as such re-examine what is in fact an appropriate remedy or an appropriate penal provision or punitive provision in these circumstances.
I'm muted, thank you, Leah. And so then we continue on to our why we have to understand this as questions of violations of human rights. And so Rhonda Copeland, she says, when stripped of privatization, sexism, and sentimentalism, gender-based violence is brutal, systemic, and structural, and it has to be seen as no less grave than other forms of inhumane and subordinating violence. These forms of violence that we otherwise recognize in international law as violations of the highest norms. And so this also translates into our domestic conversations. And we've covered this already in terms of the international law framework, and lovely presentation by Roxanne George a few years back. And I pulled from a few of these references, and so you'll see some of those. And so we have specific obligations that have developed in the context of international law, the Convention Bellum du Para, CEDAW, the recommendations, the SDGs. There are a number of robust indicators that have been developed that we can use for different entry points into advocacy and different entry points into broader legal engagement. And you hear me talking repeatedly about broader legal engagement rather than, say, the question of strategic litigation, because the purpose of this session is not, necessarily the type of strategic litigation that is frequently sort of the poster of high lawyering. Instead, it is that these are the spaces of engagement in the domestic violence protection orders before the family courts, etc., where most people experience justice. How do we infuse these questions of international human rights law and constitutional human rights to say to a magistrate, this is not a question of benevolence. This is not a question of you being nice or being in a good mood today. This is a question of what are the state's obligations and what is the role of the judiciary in fulfilling those obligations. And so you see a number of international declarations, the Vienna Declaration, the Beijing Declaration, etc., that begin to spell out over time the nature of women's human rights obligations and what that then means for the state. So one of the key ones we're interested in is the right to equality. And generally, we know that there are three obligations attendant to international human rights: the obligation to respect, protect, and fulfill. We're most familiar with the idea that the state is not supposed to violate rights. And so we know that if and when, let's say, the police directly engage in violence, then there's a sustained pattern, then we know that the state may have violated its negative obligation not to harm, right? But what then about obligations to protect? And we use protect then to mean that the state has a responsibility to prevent third parties from interfering with the right to equality and violations. So this is where we're talking about the case of the domestic partner. We're talking about the case where this is not the state being the one engaging in the act of violence, but the obligation of the state to protect means that where it is that the state is aware and the state, there can be no question that the state is aware of the level of violence. All of our reports to international treaty bodies, etc., they play this out. And this is then, the importance of connecting this data, using data to help us tell stories. You move from the data down to the individual so that the court is aware that this is a grave and systemic question and that obligation to protect arises, right? And then likewise, the obligation to fulfill. And interestingly then on Tuesday, many of the questions around the failure of the magistracy, etc., the failure of the police around these obligations to fulfill, that's where that question of, well, the police need training, the magistrate need training, they need greater resources. How can a department of 2 persons deal with something that we have recognized as a systemic threat, right? And so when we think of and we hear, and when we have to sometimes drill down into the details, when we begin to talk about crime, there's a certain form of crime that we think about. And when we look at the data across the region, it's fair to say that women live in a state of emergency relative to gender-based violence. And yet, the type of responses that we usually see mobilized around an SOE, because it has a particular form, right? So when there is a sudden eruption of gunplay, 5 people, 6 people are killed, we have to act. But if it is then that you have 20 women being killed over a year, 2 years, significant forms of violence appearing before the court, because this is now a sort of slow burner effect. It is less dramatic, it doesn't make the news, etc. The type of state responses that we see, those vary. And so understanding the gendered nature of how the state treats the crime helps us then to fill in this framework. Leah?
Just to add, I heard Professor Raddock in discussing this same issue speak to the almost inevitability of violence against women, that there's almost this idea of it being inevitable, of it being just a part of life, that certainly not within the realm of state action, evidence, data, and meriting that type of approach.
And so how then do we challenge this? And this is where we're saying that the uses of international law and domestic human rights are so useful. And we're going to be talking specifically about due diligence, because this is one of the accountability questions and one of the ways in which, when we are before the court addressing the question of a protection order, when we're thinking through questions of the ways in which there may be police failings, etc., how do we, if at all, mobilize the power of human rights? I'm just going to do a quick check in the chat to see what we are seeing. And of course, I'm seeing Kimberly. I think this may have come on at the exact moment that Marsha's signed in for Manapi's song Hookin' Me, and the very problematic nature of it. And even the sort of discussion that came out of Marsha's engaging around this. He hasn't said anything wrong. He loves her, etc., etc. And what is interesting then is around the complexity of how these expressions of love very quickly in a region where 1 in 3 women experience gender-based violence, how those then look like possession, how those look like violence. And so I now I see Yvonne asking some questions. So Yvonne, you have a few comments. I'm going to give you the chance then to jump in here.
I didn't really want to jump in. Obviously I'm a member of OSS, and my father's a lawyer, so I've always been interested in the law. But it seems to me that I kind of feel almost a sense of futility, which I don't want to feel as a member of the team, as I do feel that governments have an obligation based on the international laws that exist. And I'm wondering what the role, how can lawyers, can they be a part of agitating or being activists and saying, guys, you need to do better. I mean, governments are voted in, they're voted out. And I've not seen in 25 years really a sense of this being something that has ever been discussed at that level, at the state level, at the national level. So it's almost like we're at the bottom here, or the lawyers are in the middle, and the police are above, and then the magistrates are above, and the judges are above, and all of us have a responsibility to do it. But how do you think as lawyers, other than the fact that we're doing this training, do you think as lawyers that there is a way that we can utilize lawyers to ensure that this is something that is discussed at the highest level? Because I've never heard anyone discuss this at the highest level, but I've heard anecdotally situations where magistrates have said some pretty, as a lecturer at UWI, if I said those things to a female student, I would be hauled over the coals by my head of department. In fact, I'm pretty sure there would be a disciplinary action against me if I made the kind of comment to my students that magistrates have been known to say to women in court. So that's one of the issues I have a concern about. What kind of censure? And then the other has to do with the fact that this is not a lucrative form of the law. You know, it's, I guess, torts and criminal law and all the other things that are seen as more important, you know, conveyancing and stuff is. So how do we get lawyers to be fully committed to being activists as citizens of the country? They're not just lawyers. You know, there are men who have wives and sisters and mothers and grandmothers and goddaughters and nieces and granddaughters. How do we get lawyers themselves to become, this is the first step, of course, but those are the things I'm just kind of mulling over in my brain. I've asked a lot.
No challenge there. Yvonne, happy for the fullness of the engagement. And I think, Leah, there may be a couple points that you may wish to jump in on, particularly around some of the experiences in Trinidad, where I think there's a more robust culture around activism, but even that is still very much nascent. But I think the difference that you may notice in, say, Trinidad, for example, is one, Trinidadians are much more generally litigious. And so there's a much greater volume of cases. So if we look at the COVID-19 challenges, there have been 1 million and some COVID-19 challenges out of Trinidad, whereas we've had, I think, maybe 1 or 2 formal challenges. And then even in the context of our judicial system, those have sort of been slow walked as important, but not urgent, right? So working backwards then through some of Yvonne's comments, and some of them we're going to specifically talk about around how can lawyers better engage, and how can lawyers better engage through being in community with activists, with persons who are engaging directly with victims and survivors of gender-based violence in a way that allows lawyers to be instruments of addressing and challenging power, rather than lawyers sort of dictating the ways in which how something should be responded to in circumstances where, as an activist, you very well may know that the thing that the lawyer is seeking to get may instead be harmful for the community. This may not generally be true in the question of gender-based violence, but in working with vulnerable communities generally, that's one of the key considerations that we think about. And I'll pause, because we're going to deal with the question of the specific how can lawyers do better. I only will say that I don't want men to engage in these questions because they have wives and because they have sisters. Because if they did not have wives and if they did not have sisters, the recognition of women's humanity is the base point of how we get this conversation. Because, you know, women, the sorts of, we don't have these sorts of parallel conversations around women appreciating men's humanity, et cetera, because they're brothers, because of course it is a point of emotional connection, but it centers then men's experiences and proximity to women as the basis for their action. And that really is then, I think, part of the systematic challenge that we have. And now, you know, working in the gender space, I can't say how often I am saddened that when we do these types of training, that it's 95% women who turn up. And so it's like, you know, men broadly speak of human rights and sort of the interested in challenging power, but they're very specific ways in which these questions arise. And even if we think about who may be hailed as public lawyers, etc., the extent to which this forms a part of that focus is a question that we might want to think a bit about. Leah?
Sorry, just having a little bit of background noise on this end. I think you hit the nail on the head. I heard when I popped in on Tuesday, you were talking a bit about strategic litigation, but also, you know, having to discern and sort of exercise discretion in figuring out when that is going to be appropriate or when that is going to actually get the outcome that you want. So I think it's not going to be like just one clear answer or one step process. We really do need to understand litigation or lawyers, the role of lawyers as one tool or one part of a broader picture. And I think it's important for us to understand what the objective is. The objective would, of course, be, a cultural shift. The objective may also include requiring the state to take certain actions. And in that assessment, or in assessing, how best to get these, fulfill these objectives, I think that's where, we can figure out where litigation, what role litigation plays in that, but also, as Rashad would have mentioned, how then attorneys can perhaps liaise with activists, or how then attorneys are able to align with strategic advocacy that may be going on an issue. So, for example, when we talk about lawyers, it may not always be that an attorney is working in the courtroom to challenge state inaction in that manner. But in Trinidad, many attorneys also work behind the scenes with NGOs and use that access and use that understanding that they gain from sessions like this to then advise, okay, so this is what you need to be writing to the Attorney General on. These are the areas in the legislation that needs changing. We are now celebrating, I think, 20 years in Trinidad since the passing of our domestic violence legislation. And I have had the privilege to see a little bit of the behind the scenes machinations in how that came to be. And it is very much a collaboration of attorneys, activists, certain persons with political will to make the change, and even some sort of ability to understand when the time is right to make a certain push in a particular direction. And of course, I think, Rashad, you touched on it as well, even in the understanding of what makes this, how to make this an attractive area for attorneys. I do think there's certainly a gap in the human rights approach, or these type of matters being challenged from a human rights perspective, both in international courts and local courts.
Right. And then now to jump in, and so Leah's experiences then having the benefit of the Trinidadian experience. And we've also had that sort of engagement where we had the 2016 amendments to the legislation in Barbados. But I think where Operation Safe Space, for example, comes in is recognizing the gap between the work that attorneys are doing and the needs of communities. So how then do sessions like these and specific capacity building, how then do we get to a place where, and you'll see it later in the slide, but I'll point to it now, where the type of familiarity that criminal lawyers have with the Constitution and human rights as a part of the everyday conversation of a fair trial, etc., that fair trial, the right to a fair trial, the right to fair recourse from the judicial system, that arises in the context of family cases as well. And so now being able to have that appreciating the human rights dimension of this domestic violence case, of this maintenance case, of this custody case, etc., and then the various points of engagement. Not every matter you're going to have the resources, nor will it be wise to be able to challenge. But, you know, that might be the point, as Yvonne was saying, we do have, you know, maybe ineffective accountability bodies for magistrates and judges. So how do we engage that? How do we make sure then that the police, for example, where there is state inaction and failure, that we're able to cover those? So Leah, I'm going to hand over to you here on international human rights and due diligence obligations, and just to walk us through the Opus decision, because it really is such a critical decision in pointing to the possibilities of human rights for what we can do in Barbados.
Definitely. Thanks, Rashad. Okay, so I'm just going to briefly go through what happened in the Opus case. And to Yvonne's question, and I think some of what was brought up in chat, how you know, the actual needs of communities can be addressed through litigation and incorporating human rights, a human rights sensibility. So in the Opus case, the victim or the survivor in this matter was a woman named Nahid, and her ex-husband, Hussein Opus, repeatedly threatened her, beat her for pretty much the entirety of their marriage. On a particular occasion, Hussein brutally stabbed her with a knife 7 times. This resulted in life-threatening wounds and her hospitalization. On another occasion, he ran her down with, her and her mother down with his car. Following each of these assaults, Turkish authorities only temporarily detained Hussein and then released him with fines. Other times, Nahid and her mother contacted the Turkish police to report their lives were in danger. However, no significant action was taken to investigate what was happening or protect them. I'm sure some parts of the story already sound familiar to those of you practicing in the area or even just, you know, reading the papers. Certainly, it's very, unfortunately, still very similar to a lot of the reports that we have in Trinidad. Rather, the police viewed the attacks as private family matters to be resolved at home. Finally, in 2002, Hussein shot and killed Nahid's mother in the city of Diyarbakir. Only 1 month earlier, the woman contacted the Turkish police again for help. So I think not last year, but maybe a year or 2 ago, this was a very familiar characteristic of a lot of the reports that were making the papers in Trinidad, where women were being murdered by significant others or exes, partners. And in many, many of those cases, I think in one case there was a quadruple homicide. And it was revealed that, you know, the police had been contacted for assistance. Some cases a protection order had been, you know, issued. And I think a lot of those types of cases contribute to the lack of, I think, faith or credibility that many women feel in going for protection orders. So despite, so eventually Hussein was tried. He received a life sentence for the murder of Nahid's mother. He was then, however, released from custody pending an appeal. He argued that the murder was committed in order to protect his family's honor. After only 3 days, the Turkish police had withdrawn the protection order Nahid had against Hussein. So what was the decision ultimately? So this case was taken to an international court. And then what was the decision? 1 second. Yeah, so this case came before the European Court of Human Rights. After considering Nahid's and her mother's story, the court concluded that the Turkish authorities ought to have known about the very real threat Hussein posed to the lives of the women. It also found that the punishments had been against Hussein had been disproportionately and extraordinarily mild compared to his brutal acts against Nahid and her mother. Here, Turkey had failed the woman by implementing protection measures. So, within their obligations to respect, protect, they had here failed the woman by implementing protective measures that had no real prospect of deterring Hussein from continuing his abuse. Due to these failures and others, the court found Turkey had denied Nahid's mother the right to life and Nahid's right to be free from torture and cruel, inhumane, and degrading treatment. Additionally, with information provided by NGOs, the court concluded domestic violence was disproportionately suffered by women in Turkey. Even though there was a Family Protection Act meant to protect women, when women contacted Turkish authorities for help, they were often encouraged to resolve the matter at home, and or complaints were never investigated. Again, I'm sure this sounds very familiar. This appeared to be partly attributable to the belief of police officers that domestic violence is a family matter with which they cannot interfere. Furthermore, the court noted that perpetrators of domestic violence do not receive appropriate punishment, as the courts lower sentences for crimes committed in the name of so-called honor. It did not matter if the discrimination was intentional. The widespread failure of police officials to act disproportionately impacted women. And for those reasons, the court recognized that there was a general and discriminatory judicial passivity in Turkey that denied women equal protection of the law.
Right. And so that judgment, born out of tragic circumstances that if you work in this space, it is haunting, right? Because if you change out Barbados, Turkey to Barbados, if you change out to Trinidad, then you could be describing an incident here. But notice then the connection that the court draws between the right to life, the right to be free from torture. We've signed and ratified the Convention Against Torture, obligations, and here under the ICCPR, for example. And so, the court's connecting these rights these are the sorts of the usual high points of human rights advocacy that may arise in a criminal trial. And then the court is saying, this is linked, all of this comes together to produce an inequality. And that's why we talk about gender inequality. So you see then how the ways in which we define gender and the power relations, how those are then manifested in the way that the court is treating to these failures. And you see again, the stereotypes coming into play, the socialization coming into play, so that the court is now in its limited way, because, there's nothing to say that a judgment like this alone is the magic ingredient. It is not, right? It is a part of the puzzle, and that puzzle has 1,000 pieces, if not 100,000, right? But how then do we connect that to strategic advocacy, to engaging with the police, etc., and the possibility of systemic remedies? Now, one of the things that we'll talk a bit about later is that if you work in this space, this sounds familiar to you. If you do not work in this space, you making up this story. The magistrate won't do that. What sort of reasonable magistrate, if you go before, is going to tell a woman that she should go home and work it out because this is a nice man. Look how well dressed he is, and he speaks well. No reasonable magistrate is going to say that. And so a part of the conversation that is useful for organizations and for attorneys to do, and it sits uncomfortably with the idea that we don't talk about things that happen in court, right? But where it is that those failures within the court are going to the heart of these questions of equality, I do think there is an obligation to make this public knowledge, and then how do we translate that into the the various accountability mechanisms? How do we use that as a point of advocacy? How do we raise this as a sort of thing that amounts to a disciplinary infraction where it is that judges and magistrates are violating the judicial oath and code of conduct, etc. So the due diligence obligation, it does a lot, and you'll have the slides later just so that you can work through some of these questions, right? But we can think of the due diligence framework then as a tool for rights holders to hold states and the instrumentalities of the state, the police, the magistrate, etc., accountable. And you see then this distinction between the individual responsibility and the systemic level responsibility. In a sort of, in a case where something happens once and it is exceptional, there's no expectation that the police can always have prevented that. But certainly with certain knowledge that this is a repeated pattern, this is what we're seeing over and over, the state is now on notice that it has duties in order to protect women from the harm that is clearly existing. So not a lawyer, many lawyers. And so that's why this type of training, where at the end of it, the hope is that the attorneys who attend are then willing and able to engage with NGOs around these questions. And one of the things that in working with other regional NGOs I'll talk to the activists. And this Operation Safe Space is doing it right in terms of when engaging around projects, for example, seeking funding, you want to have a line item in the budget for legal fees. You want to have a line item that you may need to cover, say, disbursements, etc. In some cases, it might be that you may need to pay for an attorney's services. More often than not, I think once attorneys are in the space and they have the capacity and the ability to, that you may be able to get a cadre of attorneys involved in this on a pro bono basis. But ultimately, you want to have resources, whatever resources are necessary. And so that's then pushing funders in the direction of saying, actually, it's important that we have a useful line item in the budget that enables us to engage attorneys, because we need that connection between lawyers and activists. And then we can break down Yvonne. And again, when I had spoken to Marcia about some of the work that was happening with Operation Safe Space and others, activists, those involved, those who are working directly with victims and survivors, those who are accessing services and care, but it's also a role for the artists, right? How do we tell these stories? So the work that you're going to be doing and translating this into something that people experience, and they experience it viscerally, because this is a story that now relates. These are all of these connected points that we have to be able to use to change the culture, to transition consciousness towards the recognition and valuing of women's equal dignity in Barbados and the Caribbean. And that might then be a useful point that this is something that we want in this new charter that's going to be coming about. How do we have these explicit preambular values that say that women's value and dignity, in light of the historic inequalities, have to be recognized, and that when a judge, a magistrate is engaging around these questions, that they have to begin to think about these things. So it is now a little over an hour that I've been sharing my screen. And so I like to give you a little opportunity to stretch legs, get some water. It's also an opportunity for me to get water, but I'll put it as I'm doing it for you. And so we're going to take a brief, now 4-minute break. And so we'll be back then at 6:40, and we'll wrap up with probably another about 20 to 30 minutes of presentations from myself and Leah. And feel free, if you have questions, to pop those into the chat or to raise your hand, and we're very happy to engage with you, because what's most useful is connecting your questions to the existing knowledge, etc. I won't take any more of your break. See you soon. All right, I hope you have had a chance to have your water, have a bit of a stretch. And now we're going to move into the last about 50 minutes, of which 20 minutes or so will be our presentation. And then we hope that there are lots of questions that we're able to engage with. So now then we see that there's a whole lot of work around due diligence. So there's CEDAW, the Vienna Convention, the Vienna, we've spoken about the Vienna, the name eludes me right now, the Beijing Declaration, Bellum du Para, etc. They're all sorts of concretizing this obligation of due diligence. So what does this mean then for us in the context of before the magistrate, before the court? You know, these lovely things, they exist in international law all the time. You know, states sign wonderful treaties. They may even be active participants in writing the treaties, and then to bring it home, or, you know, if you followed much of the Football World Cup, to use the sort of British phrase, it doesn't come home. We signed the treaty and international law. We're very happy with it. And we say, we have signed this because this is our firm commitment. But then how do we translate that when we get to the local level? So here Roxanne George is talking about the role of the judiciary. And in 1997, it was recognized that the fundamental duty of judges to ensure the fair and due administration of justice required judges to be alert to the manifestations of gender discrimination in the law and the administration of justice. And on top of that, that they have to do things, right? So again, you see some of the specifics of these international human rights standards so that you could also refer to them. So the SDGs, these are all commitments that we've made. So how then, and just a couple of the cases, the Velasquez-Rodriguez case from the Inter-American Court, you have the Cotton Fields decision, and we'll share all of these after. But all of these decisions are saying when the state fails in this way, that they've violated a number of rights, including the protection of the law, and the CCJ's jurisprudence around the protection of the law and the rule of law are some of the most exciting, even if challenging, developments that we've seen in Caribbean human rights jurisprudence within recent times. And we now have to begin to ask, what does this look like in the work that we do? Because, I do want to say that we're at a point that could be a sort of tipping point with the potential for activism and the uses of the law in order to challenge some things as we expand the type of work that we're doing in the advocacy space, right? So that a CCJ exists in and of itself, significant. That the CCJ has now begun to do things that when I started tutoring human rights maybe 5 years ago, and I would have been a student not too long before that. And the things that I now teach my students about human rights, they're almost heretical. They're just like, no, this is not the law, this is wrong. This is not what the Constitution says. But the court's approach to interpretation now, I think it points us in towards a possibility of an empathetic justice, a justice that is not, this question of empathy is not favoritism. This is grounded in the very values of the Constitution. So you'll remember that there's this lovely sort of anecdote linked to our constitutions that really told the story of gender and the state. So you had in the Constitution of Barbados, the preamble said, we do not want to discriminate on the basis of sex, right? So there are a couple others, race, political opinion, etc., and sex in the preamble. And then you go, so you have the preamble, and well, this explanation is for those who may not be familiar with the structure of the Constitution. The attorneys would be. But you had the preamble, the court saying, the preamble saying, we don't discriminate on the basis of sex. And I use that sort of as, let's call that the veranda. But then when we got inside the house, you found that sex, prohibition on discrimination on the basis of sex, it didn't make it. It didn't make it from the veranda into the house. Everything else did. How come? Like, how do we explain that there were 5 things and only one of them dropped out of the basket between the front door and the house? Now, it seemed a reasonable conclusion that the court said, well, that had to be intentional. You couldn't tell me that the drafter saw sex at the beginning, and then in the detail section, he said, no sex. And that was not an intentional exclusion. And so it was that the court understood that discrimination on the basis of sex was not justiciable. It was not the type of case that you could bring before a court in Barbados. And so there were a number of decisions, Nielsen and Barker, Matadine and Pointu, etc. And then we come to Nervé before the CCJ. And the CCJ says, well, I don't agree with this. The preamble is one, it's the story of values. It tells us who we are. So even if I don't find it justiciable, as in it grounded specific rights, I have to say that there's some value to be attached from it. They say that in Joseph and Boyce, that it is not mere verbiage. It has to mean something. It's the animating spirit of the Constitution. But then in Hervé, they go further and they say, well, there cannot be two preambles. You know, there's the beginning of the Constitution that says that everything that follows is enforceable. Then they look at the relationship between Section 11 of our constitutions and the remainder of the detailed section. And ultimately, and the academic in me disagrees with some of the court's reasoning, but that's immaterial to the reality that the court found that sex is justiciable because the preamble of the Constitution is justiciable. And what that means is that there are much broader rights available for us to begin to think about some of these questions. So the fact that you now have the ability to say sex discrimination is prohibited under Barbados' constitution, and that the Family Law Act must be in conformity with that, that domestic violence protection orders must be in conformity with that, etc. That is new. More than that, the sort of historic separation between international law and domestic law, so dualism, international law is over there, domestic law is over here, and the two shall meet and not cross, right? And so there's a sort of image that often pops up on Facebook. If you have an aunt that sends you a lot of morning WhatsApp pictures, it may come out, you may get one of those again, with two bodies of water that are next to each other, but they don't mix whatsoever. And because of the weight, etc., of one body of water, then they don't cross. But the idea was that they don't, international law stays over there, domestic law stays over here. But over time, we're seeing that courts have increasingly said, well, that's not an accurate depiction. One, from the early cases like Fisher, we know that where there is an antecedent relationship, so our constitutions were in part based on the European Court's Convention on Human Rights, and so we could look for connections, right? Where courts like the Inter-American Court had decided a question, we could use it like a precedent as we could use a precedent from any case anywhere in the world. And one of the things that I do want to implore attorneys to do is to begin to decenter the UK and British jurisprudence as the place where we go for precedents alone. Because they're fascinating judgments that are happening in Botswana, in Kenya, in Nigeria, etc. And they're technical questions that we have to work through, like, is this an appropriate comparator, etc. But we don't really struggle with that question with the UK's not written constitution, etc. So we can find ways to find these as relevant and usable. So I'll take you to Botswana here, because it was many, many moons ago that Botswana found that the preamble, A, was justiciable, and B, even in the absence of sex making its way to the detail section, Botswana said, this is an example. These are a list that point to the types of discrimination that are prohibited, but it is not meant to be an exhaustive list. And so they use vulnerability as the basis for beginning to think about what other categories could be included here. And South Africa's constitution did something similar. And as we move into constitutional design, we want to be able to pull from constitutional practice throughout the Global South in order to have the types of strategic anchors, that reference in the preamble that you're going to use in 10 years to say that gender equality has to mean something specific in the context of taxation or child maintenance, etc. And so in beginning to think through some of these questions, we have to expand, and we have to make judges comfortable with using a case from Botswana, from Kenya, etc. And I think we're slowly seeing that convergence, but escalating that conversation so that we're in dialogue with post-colonial states that are in many ways equally navigating the many inheritances or curses left by the experience of colonialism, right? And so I'll just end the comparison with Botswana one of the fascinating things that we struggle with is the idea that the obligations that are linked to human rights, that those are only applicable as against the state. And in other jurisdictions, even in the absence of the type of constitutional amendment that happened in Jamaica, where they said third parties, not the state, they're bound by human rights, depending on the nature of the rights, courts have found that there is the possibility of horizontal application. And that might mean very useful things in the context of gender-based violence, particularly where third parties that might not be the state are involved. But key point then is that the domestic scene is changing and there's a role for attorneys to play in that. Then in terms of the exciting possibilities, you see me make reference to this idea of vanishing dualism. And in talking with the faculty of law, had a fascinating conversation with President Saunders. And in the type of classical cryptic way, when asked about the reference in the Mayan Alliance decision, where the court said, the obligation to comply with the protection of the law requires the state to comply with its international law obligations. Now, as a broad statement, we don't really know what it means, but it sounds provocative, right? It has lots of uses because we've agreed that there is a due diligence obligation. We've agreed that there's a duty for the state to respect, protect, and fulfill obligations. And that duty to fulfill says that magistrates need to have training and that the police need to have training and adequate resources. And so when the state can find money, there's a fascinating case from India that is unlikely to be replicated, but it's inspiring the even gall of the court. And the state was shutting down a school for blind kids. And the judge said, when I look at the budget, this isn't really usually my place, but I see fireworks and celebrations. The state has had a lot of money to spend on foolishness. And if the state can find money for fireworks, certainly the state can find money to fulfill the rights of these children with disabilities, right? And so, you know, judges are generally in the region very deferential, and the Indian courts are an example of judicial activism. Some may say off the rails, some may say as a high point of the possibilities of the court, appreciating that judicial activism sometimes often can lead to trouble in terms of implementation. So the judge reins in from high, and then everybody else is left to figure out the pieces. But the point there is that that sort of questioning and reassessing the deference that is typically afforded to the executive and the legislature, that those might be useful questions in how we begin to, say, address resource constraints, artificial resource constraints. Because if you follow the budgets, and again, now this may not be the work of Operation Safe Space, but this is why we need gender-sensitive budgeting. This is why we need to have assessments of the budgets for their gender implications, so that when we see the government has said this is their commitment, but all of the priorities for access to justice are not going to areas that will benefit women or that women are disadvantaged disproportionately in ways that require responses. That's the benefit of these different forms of accountability. But of course, this means that we really have to ramp up civil society capacity to engage with these questions, because we know that the state is not going to willingly take it upon itself to A, pick up more work, and B, more work that is possibly going to say, you're not doing your job, right? And so that's the role of this of civil society, the role of the media. How do we make these connections that makes it difficult for the state to decide to not act? So approach to human rights. Leah, go ahead.
Yeah, I just wanted to jump in before you move on. I think that section that you just went through is particularly important, because I think there is a role in addressing some of the gaps that I think we all see. There is a role of the local legislation. So we understand that there are domestic violence acts, there are family law acts with provisions that work, that don't work. So the recent amendments to the Domestic Violence Act in Trinidad and Tobago was a result of that review and analysis and adjustment based on input from practitioners, et cetera, et cetera. So that is one realm, I think, understanding the limits and bounds of the local act, and where then that needs to continually be, those bounds need to be continue to be adjusted to ensure that we really are being effectual. In addition to that, though, I think why it's so important to ground this in human rights is that, particularly with, these types of matters, and I don't know, what particular category you would want to put this in, but you see with refugee matters, with gender equality matters or domestic violence matters, and with refugee matters and LGBT matters, LGBT protections, advancements, etc. Attorneys have to be very creative, because a lot of times you are either working within a situation where there is no local law directly speaking to the issue, or the local law is very cut and dry that, we're not abiding by certain things, or, we may have signed that treaty, but we're still going to put the refugees into detention centers and you can't do anything about it. So there are, when the law almost seems to give you no other options, I think it's very important to be creative and understand how bringing in human rights and bringing in those international cases can open up so many doors. And even as Rashad was mentioning, utilizing global south cases. So especially with some of the advancements around, LGBT laws and the striking down of some of those laws recently across the jurisdiction. It was when you look at those judgments, it's a lot of back and forth. For example, the Savings Law clause, the Indian court citing the Trinidad court citing the Indian court, citing the Botswana court, barely a UK or New South Wales in the mix. So I think even understanding within our particular context, how to lean on that commonality of experience to really start to create jurisdictional specific, remedies that really get to, fulfill the objectives that we want in this particular space.
One of the interesting things then that Leah touches on is the importance of intersectionality in the work that we're doing, and also coalition building, right? Because when you get a good judgment, so in Nerve has nothing to do with what we're talking about here specifically, right? Nerve was mandatory death penalty, classic criminal law case. But Nerve gave us, one, very limited uses of the Savings Law clause, if any. Two, justiciability of the preamble. And three, broad understanding of the protection of the law. One of the things that we've noticed is that, and if you take, for example, the recent judgment from involving the mandatory sentences for gun-related offenses in Barbados, in my reading of the judgment, what you had, even though it was a good judgment that raised the human rights issues, and it came to the conclusion that I think is consistent with the jurisprudence, the technical uses of what you're seeing on the screen here in terms of the modern approach to human rights and the steps weren't followed faithfully. And one of the things, we'll talk about this, is how, depending on if you follow the steps correctly or not, if you don't follow it correctly, it might be that you find yourself as the person challenging the particular act, etc. If you go the route of a constitutional challenge, you find yourself with the court saying that the duty is on you, the claimant in the matter, to bring evidence to show that it wasn't justified, for example, as opposed to just saying, as has been accepted, that the role of the claimant is to demonstrate a prima facie case that there's interference with something that's protected. So your job is to say, look, this is what the Constitution says, this is what's covered under it, and this is the action which is impinging this. But if the court says, well, that's fine, I see that, but you have to tell me that this measure is not justifiable, I was just like, well, actually, no, not my job. I can't tell you that it's not justifiable because you're the one with the AG's chambers, you're the one with technocrats, you're the one with access to UN funding. You must tell me that the police do not have the money because of XYZ. It is not my role. You have to justify instead that you must instead demonstrate that there is the state that is must demonstrate that the measures that were adopted are not adopted, that there was some legitimate aim, there was some rational connection, and that there was no less restrictive means of achieving the same. And so working through the technical specifics of this modern approach to human rights, where we no longer presume that Parliament only acts in the interest, the best interests of society, and that Parliament legislates for human rights in every occasion, because of course, we know Caribbean governments would only do that. And so the courts have slowly begun to change that sort of approach, where the presumption of constitutionality does not function in that historic way. And then the burden is now lower on the claimant to just demonstrate that prima facie interference, and the burden then shifts to the state, etc. So now, how do we tie this in to some of the larger questions as we come down the home stretch? And this is around engagement. How do we engage these questions? On the question of strategic litigation, we're asking, well, is there a human rights concern in this domestic violence protection order? Is there a human rights concern in the magistrate's comments? Is there a human rights concern in the budgeting, in the types of allocation? So if it is that an officer has had 5 credible complaints and the officer still remains on duty in this particular department, judgments from even the Privy Council say, well, that might be a little problematic. And that raises protection of the law issues, right? But so we first have to identify, is this actually a human rights concern area? If yes, how do we connect that to the international law standards, etc.? What are the varieties of understandings of human rights that might help us to frame or understand this particular issue? So is this then that we're looking at this from a perspective of judicial accountability and the rule of law? Is it that we're looking at this from a right to equality perspective, etc.? Is this a freedom of expression question? Is this a case where we're talking about the right to privacy? You know, there's so many dimensions that we want to be able to have the best understanding of a robust and rounded, so that we know, okay, this is not a case for strategic litigation. This is a case where we're going to appeal the magistrate's decision on this question, because we want to have something from a higher level, so that magistrates have guidance on this question. We might want to say, well, okay, no, I don't have time to fight up all of that filing, but I am going to file a complaint. I'm not going to file a complaint, I go into the media, or it might not be me to go to the media, but I'm going to prepare the survivor or victim to be able to converse with the media about their experience. If it is as an attorney, you may not necessarily feel comfortable because this is sub judice, etc. But one of the things then that around, and I think attorneys must become more media savvy, being able to directly talk to the media while balancing the sort of concerns around fair trials, etc. But it isn't uncommon in a modern sort of practice that we have to be able to talk about these things and to be able to frame conversations, because that's also what's changing hearts and minds around some of these questions. But if we're going to litigate, is litigation likely to lead to more harm? So if you know, when you look at the bench and you see, when I assess each of these judges' judicial philosophy, this doesn't make sense to bring this particular case, because inevitably what we're going to have is a decision that is so bad that this will set us back 20 years. Now, in the context of the, say, CCJ's general jurisprudence on human rights questions, maybe not on employment law questions, but on human rights questions, we see the court adopting a robust approach. But of course, there's a question of, you know, it's exceptional for the court to jump over the Court of Appeal. That happened once and probably will only happen once. So you know, is this something that the claimant, the potential claimant, is interested in this long haul disruption to their life? The judicial process is a disruption. The court attendance, the being in the news, all of these things are things then that say Operation Safe Space and organizations like them have to be able to say, okay, well, we're going to need to have social and emotional support for this claimant. We're going to have media training. We're going to have all of these things because this will require a whole lot. And more often than not, because we're dealing with persons who may be coming from vulnerable backgrounds, who may not be media savvy, etc., we have to be able to put them in the best position to be able to navigate it, not just for the ultimate case outcome, but centering their well-being. You know, there's some cases where it might be the perfect legal case, and we decide that the interest of this particular claimant is not met by bringing the litigation, for example. And then, of course, you see this continuing question of engagement. Should the focus of the conversation then be on issues that do not center on the court? Is this where we're trying to get a reform of the requirements for being a magistrate or the requirements for police training? Can we modify those sorts of things? That's where we want to think about all of these varied inputs. So we've covered this. Does the social or societal problem have a legal issue? Sometimes it's not that the law is bad, the law good. It's the implementation. Is judiciary a judiciary that is right sensitive? Has there been the type of training around novel issues? You know, while judges and the type of skills that we have as attorneys are generally open to being able to research broadly, there's also the sort of question of judicial culture and judicial comfort. And so non-court experience or engagement with the subject matter might be helpful in making judges broadly aware of types of issues. So if a judge is aware of intimate terrorism, does that judge then, in light of intimate terrorism, treat to this case as situational violence? Does the judge say, well, this is the type of case that I still see love. I see the way that he looks at you, that type of foolishness. Does that put the judge in a better position to make more informed judicial pronouncement, even on, say, a question of provocation? And so a number of considerations for us to think about in these questions of engagement, so that in the domestic violence protection, where the protection order is rejected, is this the type of case that is so strong? And of course, on questions of these, where the appellate court is going to ask, was this a reasonable exercise of the court's discretion? We may have come to a different conclusion, but it's not so wrong that we could challenge it. And of course, resources, etc. There might be a point where we say, no, we're seeing a sustained problem here. Or, and it's difficult to do these types of challenges where, because you've collected statistical data, you see evidence of unequal protection of the law. That's the type of work that requires years and years of research. And even in the US, where that sort of jurisprudence was sort of piloted, they started with a very strong endorsement by the court, but discretion by police officers, that then became an area, for example, that the court was less likely to robustly engage with. And so in my work with in Caribono and Caribono working with URAP, there are some lessons that were learned elsewhere, and this is pulled from one of those previous presentations. You need to have lawyers in consultation and partnership, meaningful partnership with clients and the civil society organizations. Lawyers, in some cases, they turn up for the case, but it is social movements. It's the work of Operation Safe Spaces, advocates like Marcia, etc., that keeps the fuel going on these questions, even when they're not in the newspaper, or when they're in the newspaper so often that nobody pays attention to them, right? How do you connect the judgments, cases, etc., to broader advocacy? How do we make sure that the research is so thorough that the judge cannot help but feel comfortable to say that the best arguments have been presented to me? If I tried, I couldn't find better research. And this is now consistent with the international human rights obligations, the nudges and trends that we've seen from the Caribbean Courts of Justice, etc. And then, of course, expert evidence. This is one of the areas where we want to engage with our sociologists, we want to engage with our criminologists, etc., to be able to tell the story of data and to translate this into the structural context in which it exists, rather than the individual type cases that when a judge is focused in on this individual case, they miss the context, for example. And we're coming right down to the end. I think there are about 2 more slides. This was an interesting judgment from Trinidad, the state and Richard Clark, and it was a sentencing judgment. And it was a short note at the end of the judgment. And the judge implores all those involved in the process to have a look at the UK sentencing guidelines on assault and other offenses against the person, available online. But this is where I was struck by this language from a judicial officer. And she says, I note that this could easily have been a murder-suicide, indeed a double murder-suicide, not an infrequent occurrence in this country. May I add that if you, or if there's anyone who still believes that infidelity or ending an intimate relationship can justify or mitigate violence, you are severely mistaken. Anyone is free to end an intimate union, whether it is in the context of marriage or merely a visiting relationship, as in this case. And she says, perhaps in an effort to re-socialize against skewed gender stereotypes, we should reconsider the utility of the words, till death do us part. But again, here we see the judge invoking many of the things that we've been talking about in order to exercise that sort of judicial accountability for ending gender-based violence. And so what can we do? How do we report? How do we record? How do we make this public? How do we have knowledge that this magistrate has said these 15 ridiculous things? And so if I sent this after the one complaint, the complaints authority might say, well, that's a one-off. I can't really do anything with that. But if you have a second, and if you have 15, then it's okay, well, this is an issue that requires censure. How do we get this into the media? How do we get this into public conversation around some of these questions? The types of research where you see in Belize and Trinidad that judges had really harmful gender stereotypes as the basis of some of their actions. And so when you now have this research, it requires judges to reflect a little, because it just doesn't look good. When you see 60% of judges believe X. So, these are our judges. And then the accountability mechanisms of all kinds. How do we work through, whether it's a high court action, whether it's an appeal, whether it is in the process of the application for the domestic violence protection order in and of itself? How do we build in these sorts of accountability mechanisms where when we see the system failing, that we don't resign ourselves to the inevitability of failure? That's just how the system is. It don't work. We know that government can work. Government works with sometimes lethal efficiency when government is wanted to work. How do we transfer this sort of efficiency through the uses of the accountability mechanism? And how do we now translate? You see me earlier, I spoke about the value of human rights as giving us a vocabulary for struggle. So how then, when I am making an application for a domestic violence protection order, how do I remind the magistrate that this is not a sort of airy-fairy decision, that the magistrate must consider these X factors? And there are a number of indicators that have been developed internationally that then might be more useful in the concrete context of the domestic violence protection order, right? Where they say these are the things that we want to look at. And there are a number of these access to justice guides and good practices, etc., that we may benefit from, but also the benefit of sharing your experience. When you see something has worked in your case, how do we share that with other attorneys so that who are interested in doing this work, so that they too have tools that have been developed in our local context to use effectively? Because we all know that something can work brilliantly elsewhere. That's because of judicial culture, that's because of a whole variety of factors that might not be present in our specific context. So those are some of the steps that we want to take. And that's a wrap then from us. And we now open for questions.
Hey, Rashad, I'm sure you would have seen the question from Japto.
Right. Well, I don't know that that requires a sort of certainty in the appellate process result. The safest thing that we can assume, and even that we can't be too safe on, is that in these types of applications, you're not likely to have costs awarded against you. And so because courts have realized that these are important human rights questions and that it would be useful for these matters to be litigated and brought into the public, that they generally will not order costs. But there have been a few exceptional cases throughout the region where a court may defer from that normal thing in ways that are concerning and represent a challenge to that type of litigation. But again, this is why the connectedness of this all. So when the conversations around reforms of rules of practice, that have nothing to do with family specifically. How do we influence those spaces so that we're now beginning to think, well, no, I need this specifically reflected in the rules because this is going to have relevance to the ways in which we work. So if we're talking about, let's say that we want to have accompaniment to court for non-lawyers, where you might have advocates who want to. How do we crystallize that in a way that it is not as discretionary as it has been in some jurisdictions?
I have a quick follow-up question, Rashad. Do you agree that the judgment for damages is inevitable with the same confidence and optimism that Janta has?
I certainly don't, to the extent then that there's so many factors that goes into and if you study our courts of appeal and the times that the courts of appeal has been overturned on some human rights questions, for example, then you know that this is for the long haul.
Yeah.
And if you have, there's a question of, okay, well, attorney fees may be racking up unless we've got, if not attorney fees, then the fees for disbursements, etc., those are also racking up. Now, do I think that where there is this sort of systemic failure, that this is not an appropriate question for vindicatory damages? I think that that's a fair question, that where the state has failed in this way, that it may be an appropriate case for vindicatory damages. What I'm less certain of is the likelihood of the court coming to that conclusion. So there's a gap then that I think Shane points to between the ideal of, well, this is a case for vindicatory damages and they go resolve in favor of my client, versus well, this is where we are and this is the sort of treacherous waters of moving through the judicial system to get to that sort of fabled promised land.
Which is, the work that is where the work is, and really creating that culture within the family law space in which, international law, human rights law is applied with that kind of vigor and consistency. Yeah.
And so, that then the ways that I think about this is that whenever, just by way of almost habit, you throw in the international law references in some of the applications, just so the judge becomes familiar with it, even if the judge says, that had nothing to do with me, I'm not learning that, right? But over time, because it is so regular, and that's not to say that this will work, right? This is a shot in the dark with a hope that sometimes it will land, but we're not operating blindly because we're able to see what has worked in other jurisdictions, what's working.
Correct. And in a lot of those jurisdictions, it would have been a slow build that eventually culminated, as you said, in a tipping point or a transition over a threshold. But definitely, I think there is some value in starting to introduce these concepts in a more consistent way, and start to break through that barrier of the dualism of international here and our local application, our protection orders that have nothing to do with international law and human rights.
Also,
starting to challenge that.
If we, and certainly, in say, even employment law and labor law, where there may be some questions that are gendered questions. How do I nudge a court in circumstances where the legislation might be terrible? Legislation might not reflect the International Labour Organization standards, and the International Labour Organization may have said that. So if we know if you are not exclusively working in the family law space, how do we broadly now move towards a greater human rights culture in our constitutional and beyond constitutional litigation? There's a very interesting judgment by Justice Jamadar it's a case involving the renaming of one of Guyana's airports. And the question was around consultation. And it was being argued that consultation is a common law requirement. And Justice Jamadar did this very interesting thing where he said, well, that's true. But you can't tell me that we have a supreme law and that consultation does not flow out of the preambular value that says that we want democracy and that we want a meritocracy, etc. These things can only happen. And so in rewriting what were principles that had developed through a common law, in some cases a poorly fitted suit for our realities, in writing it through a constitutional instrument, there's a way then that we begin to repatriate, as it were, our laws and indigenize them. But it also then makes space for the development of the law in new ways, because we're not then limited to, well, this is how British courts have decided this question, because the locus of the focus is not exclusively on the common law. It might be, is there a constitutional dimension to this? And the CCJ judgment, particularly Justice Jamadar, because of his public law expertise, whether it's a company law case, whether there's a judgment involving sexual violence in Guyana, and again, rewritten through the language of international human rights law, etc. The reality is that there are not many judgments that cite CEDAW or the CRC or the ICCPR, etc. How do we slowly build that culture? And of course, when we're talking about magistrate, no judgments there to be had. But how do we integrate this into the everyday vocabulary of the ways in which we work? So the time now being, so Nyla says, I was interested in the 3 types of domestic violence. Many of the cases didn't fit the cycle of abuse. They were situational. The danger in the traditional description is that persons do not recognize that they're in abusive relationships, or at the very least, they're toxic relationships with the risk of escalating to true danger. And so, interesting then, I'll share also the Johnson's work on this question. That's where that typology comes from. One of the dangers of typologies is that they create sort of a fixity, a closedness. So this is intimate terrorism, this is situational violence. And so figuring out the dynamics of fluidity, when does this escalate to X, for example, might be useful for us to think through in some of these contexts. But, situational violence, for example, the court may take robust protective measures, and the court may say, is this a case where, are you interested in counseling? Are you interested in, given the context of interpersonal relationships, etc., the court may say, okay, you need to be safe in the house. Is this a case where we need to have counseling? Is this a case where there's some other type of remedy that we may want to consider, given the type of violence, if this is situational as opposed to intimate terrorism, for example? But the court also has to be very careful that it doesn't make allowances for situational violence, for example, to result in fatal or even significant harm to women and generally to persons affected by intimate partner violence in Barbados. So with 4 minutes left before our cutoff time, unless there are any other questions, I'm going to hand over to Robin. And if I allow you 2 minutes earlier than you had anticipated, then I'm happy and I have done part of my job.
Thank you so much, Rashad and Leah, for a robust and informative session. It was very informative and it was amazing to be a part of. And we hope that you will join us maybe on a few of the forward sessions, possibly to engage in a bit more dialogue as we move through the different subjects. Thank you to everyone this evening for again joining us. Our next session will be on Tuesday next week, August 10th, same time, and you will be receiving the link for it as you did today. And of course, in the meantime, if you have any questions at all, please feel free to reach out to us by email, operationsafespace.bb@gmail.com. Thank you so much. Good night.
Good night, everybody.